Testimonial evidence. Witness competency. Testifying witness must be competent, meaning they must satisfy requirements of basic reliability. Witnesses are generally presumed to be competent. Competency qualifications. To be competent, witness must have 1. Personal knowledge. Witness's testimony must be based on her own perception, what witness saw or heard. 2. Memory. Witness must have the ability to remember, must not have amnesia. 3. Communication. Witness must be able to relay her perceptions either directly or through an interpreter. 4. Sincerity. Witness must take an oath or affirm to tell the truth. Diminution of any of the above capacities usually goes to the weight of the testimony. It makes witness less persuasive. Excluding witnesses. Upon a party's request, the court must order witnesses excluded from a hearing or other witnesses' testimony. It does not apply to parties or a party representative, where party is a non-person entity. Use of documents by witnesses during testimony. Present recollection refreshed. Use of documents to refresh witnesses' memory during testimony. Anything can be used to refresh a witness's memory. Witness cannot read aloud from a document, but can look at it briefly, then continue testimony unassisted. Opponents may inspect and offer into evidence anything used to refresh witnesses' memory. Document is not read into evidence, distinguished from recorded recollection. Recorded recollection is when the contents of a record or a document witness previously made or adopted is read into evidence. The requirements are that 1. Witness had knowledge of the record subject matter. 2. Witness's memory is insufficient to testify as to the record's contents. Present recollection refreshed was ineffective. 3. Record was made or adopted by witness when the matter was fresh in witness's memory. And 4. Record accurately reflects witness's knowledge. Note: recorded recollection is a hearsay exception. As such, it may be read into evidence, distinguished from present recollection refreshed. Objections to form of question or testimony. Form of question objections are 1. Calls for narrative, non-specific, open-ended questions that allow witness to tell a story rather than give specific testimony in response to specifically asked questions. 2. Leading. Questions itself suggest an answer, improper on direct unless witness is hostile or an adverse party acceptable on cross-exam. 3. Assumes facts not in evidence. Question makes an assumption which has not been established on the record. 4. Argumentative. A question that is not designed or intended to elicit relevant facts, but rather is an argumentative assertion. 5. Compound. Questions that ask more than one question at a time. Attorney must ask questions individually. 6. Beyond scope of direct. Arises on cross-exam. Attorneys must confine their questions during cross-exam to the scope of the direct. They cannot ask questions involving matters not discussed on direct. Testimonial objections. Unresponsive or non-responsive. Witness's testimony does not relate to or directly answer the question asked. Note, these objections must be specific and promptly made, otherwise they are deemed a waive. Lay opinions. Testimony in the form of opinion is inadmissible unless witness qualifies to give either lay or expert opinion. Lay opinion requirements. Opinion testimony is admissible if it is 1. Rationally based. Opinion is rationally based on witnesses' perception. 2. Helpful. Opinion is helpful to the trier of fact. It gives the jury more information regarding the witness's perception than the perception alone. Legal conclusions are inadmissible because they are deemed unhelpful. And 3. Not expert. So not based on scientific, technical, or other specialized knowledge. Not in the realm of expert opinion. Examples of admission, lay opinion testimony, speed of a car, emotional state of an individual, voice or handwriting recognition, sense recognition, and intoxication. Expert opinions. Experts may provide opinions or facts or issues in the case. Expert opinion requirements. Expert testimony is admissible if 1. It's helpful. Expert opinion must be helpful to the trier of fact. Expert uses specialized knowledge to reach a conclusion an average juror would not reach alone. 2. Qualified. Expert must possess special knowledge, skill, experience, training, or education. 3. Reasonable certainty. Expert must believe in her opinion to a reasonable degree of certainty. 4. Proper factual basis. Opinion must be based on facts. Expert must base opinion on admitted evidence, personal knowledge, or admissible evidence properly relied upon, such as data, other testimony, and experience. Reliable. Principles reasonably relied upon. Scientific evidence. If expert opinion is based on science, court also considers whether evidence is peer tested and capable of retesting, published, has a low error rate, and reasonably accepted in the field of study. Scope. Experts may render an opinion on any ultimate legal issue. Exception. Experts cannot give opinion on defendant's mental state in a criminal trial if it is an element of crime or defense.